Same. Okay, we are live. So we're on, let me go ahead, JC. We are live here on YouTube. For those of you who have come in today, we want to say thank you ever so much. I'm going to do a quick little introduction of my guest here, JC Johnson. JC is a real estate attorney, but it's specifically a land and ranch, someone that specializes in land and ranch, and here to answer your questions. So please be sure if you've got anything, any specifics that you want us to cover, put them in the chat box and we'll be happy to answer anything that you've got. So with that, JC, I'm going to turn it over to you and just let you kind of introduce yourself and you know, how did you get into doing what you do?
Absolutely. My name is JC Johnson, and I'm the managing equity partner for the law firm of Dorset, Johnson and Swift. We have offices in Fort Worth, Texas, Houston, Austin, and Brownsville with a statewide practice. I've had the opportunity to be in the real estate industry for 30 years this year, both as a broker, a title insurance executive, and a practicing attorney. I got into the industry actually being a broker for farms and ranches, and grew up with agricultural background, so it's always near and dear to my heart, even though my practice has branched out into other areas of real estate and business. And I'm glad to be here to be able to answer some straightforward questions that come up as you look to buy and sell farm and ranch property, and also to help those that are helping others, such as our real estate brokers, and those that are in agricultural lending, and the others that are helpful along the way.
You know, I'm glad you mentioned the lending. My lending partner is actually going to be doing a video like this, very similar, except, you know, for whatever you want to call it, liability reasons. Her partnership said that they wanted her to do it, you know, screened ahead of time. So thank you for being so bold and putting yourself out there, you know, kind of in live TV, if you will. But yeah, we've got these out. So the first question that I have, and you answered this wonderfully for me in our class a few weeks ago, but when is a ranch, and when is it just a house with a really big lot? And what difference does that make from a contract standpoint? What kind of contracts you do, and you know, what are the main differences there?
It's a choice of contracts, and you're really not, there's not an acreage, because that's what the question I get a lot is, when is it a ranch? Is it 10 acres? Is it 100 acres? Is it 1,000 acres? And that's really not the question. You try to, the real estate license holders in the state of Texas, when they're evaluating which contract to use, they're really evaluating the characteristics of the property. If the property is more kind of like one of your descriptions is a residential property and happens to have a really big yard, maybe 40 acres, but there's really nothing else to it, then you could probably use the farm and ranch contract or the residential contract. And it would probably not have any type of adverse effect either way. But what's distinctively different about the farm and ranch contract is it contemplates different improvements and accessories. And I think we're going to talk about that in a bit. Yeah. But also it covers a lot of the different characteristics that whether it be recreational or commercial, a farm and ranch has, as opposed to simply a residence that has some acreage. And so that's really the factor where you want to get off. When it starts having those farm and ranch characteristics is when you want to use that TREC promulgated farm and ranch contract.
Okay. And what would be some of those main characteristics that distinguish it from a large yard to
yeah, again, from the standpoint, we start off when I mentioned it, and in looking at, we have the farm and ranch contract addresses two different types of improvements and two different types of accessories. It talks about residential improvements and residential accessories, and that's what's going to be mirrored on that 1 to 4 family contract. But then it goes into farm and ranch improvements and farm and ranch accessories. and the laundry list, if you will, is different and unique. It also addresses different components of different types of leases that could be involved with the properties that go beyond simply a residential lease. From that, it delves in and confers over to things like our natural resource leases and touches upon those. And we're starting to see that. All of our TREC contracts, just as a note, had some revisions that I think have improved all the contracts, including the farm and ranch contract. And those are out for voluntary use currently by the real estate license holders and will be for mandatory use on April 1st. And so some of that's changing. But if we look at the farm and ranch contract overall, it's addressing these characteristics throughout the contract, things that are unique for farm and ranches, for larger acreages that help the license holder and the buyer and seller more capture the business deal, if you will, in the acquisition and sale of this type of property.
Okay. So we've had a few more people join us, and if I'm repetitive on this, I apologize, JC, but I just want to remind everybody out there viewing that if you have specific questions, if something that JC or I say that sparks your interest, or if you have something that you want us to cover, please be sure and put it in the chat box. And last video that we had, people with were having trouble with the chat. If you leave and then come right back, that seemed to fix it last time. I had a conversation with the YouTube president, and she assured me that it was going to work good this time. And you and I did talk just before getting on here that we could dedicate a whole hour of playing like a game show that is this an improvement or an accessory? And for those of you who don't know or don't remember, improvements are what conveys with the property. Accessories don't, right? So if you're looking at a traditional 1 to 4 family home, anything that's attached to the house conveys. That's an improvement, and anything that's not attached, like a washer, dryer, refrigerator, things like that, those are accessories, and they don't naturally convey. And so
we have to remember on that, and I'll kind of piggyback on you right there, is that's where the contracts loop in under the property being sold. If we look at improvements and accessories, it lists certain types of accessories that are actually going to be part of the deal. And that's a real balancing act. And I think that's where you're headed with this. I just want to make sure that everybody's following down the right silo, is that the improvements and accessories that are listed on the TREC contract, all of that's going to convey. 100% correct in the fact that the improvements are things that are considered real property under the old real property test. It's that, as you pointed out, those are things that are attached to the property to the extent they cannot be readily removed without causing damage of a certain level. The accessories are more like personal property, not real property under the traditional test, but they actually help the real property perform from a standpoint. And what's unique about this farm and ranch contract is this bifurcation, if you will, not only of improvements and accessories, but of residential improvements and in farm and ranch improvements, and then of residential accessories, and then farm and ranch accessories. We look at the difference of those as from a standpoint, and I think that we take let's take an accessory, something that's probably not real property, so it doesn't have this attachment factor from that. And so it's a hunting blind. Say you're buying a property and it has 14 nice hunting blinds, and any of those that are out there that like to hunt know those are fairly substantial in pricing, especially if we have tower blinds and things like that going on. Now, obviously, unless they are sitting on a slab and attached to a scenario, those are easily accessories that can be removed from the property without causing any damage to the property. A lot of them are on skids. However, it needs to be addressed whether that's coming or going, because it can easily come into question whether that's being acquired as part of the property or not. And that's a specific thing that's listed there in the accessories, because you can't hunt the same without those blinds. and
Yeah.
from the standpoint, so it affects the use of the property, even though, and so we've created over time, the commissioners have created through the broker lawyer committee, have created these kind of lists. Now they're not exhaustive, and we have to think about them. Anything that's on the list or similar to something that's on the list would be in that category. Great listing agents will help in the promotion of the property, in the fact that they will do a thorough job of capturing what is to be conveyed to the buyer and what is to be retained by the seller. But by the same token, buyers agents and buyers cannot expect everyone necessarily to be a good listing agent. And so anytime there's any ambiguity, you want to be sure and understand what the deal is. There should be a lot of dialogue. The more things that are going on with the farm and ranch property, the more accessories, the more improvements in that situation, the more communication. So anything that is in fact going to be excluded out of those lists needs to be listed under paragraph 2 under exclusion. But everything else that's on that list or similar to is likely going to be construed as a matter of contract and law to be conveyed. And so we, at the end of the day, as a buyer or seller, or certainly as an agent representing them, we want everyone to know the deal and agree on the deal so that there's no surprises on closing day.
Exactly. So, and this is probably not in your wheelhouse, and I'm not expecting you to talk about it, but that's one of the importance of dealing with ag lenders or land lenders because of the underwriting. You know, one of the things they teach you back when you're doing residential brokering, you know, underwriters will look at if you have too many accessories, too many things conveying, and they'll go, well, is this a residential transaction or is this, you know, something different? And they have to go through and figure out how much percentage of the deal is all these accessories, and can make it very complicated. Whereas if you're dealing with an ag lender and dealing with people who, you know, do this over and over again, their underwriting and their understanding of valuation of the accessories as part of the deal is super important.
Yeah, I can endorse that 100%. It's just like if you're acquiring apartment complexes, you want to have a lender that knows about apartment complexes. If you're acquiring a farm or ranch operation, you want lenders that know about farming and ranching. It's simple as that.
Yep. So I've got a whole list of things here. I want to talk about leases. You mentioned it sort of at the first, but let's talk as part of the contract. So let's not get into what I call mineral rights. You called it natural resources, which I think is appropriate because whenever I'm talking on my channel, I normally break out mineral rights versus water rights, but those really are all under the same umbrella. So without talking about water leases, mineral oil leases, natural gas leases, let's talk about some other leases that might convey with the sale of a property.
Right. And so, you know, one of the things when you're the buyer, from a standpoint, is that you're going to be concerned is how the property is currently, and especially after closing, how your new property will be affected by any existing leases. And there could be many different forms on a farm and ranch property. I already mentioned hunting. That's a straightforward. And again, a lot of people maybe listening right now know that a lot of hunting leases are structured. If there's actually a conveyance or sale, then the hunting lease terminates. But there's no such place where you go and find the hunting lease for all of Texas. Then this is the way that the provisions are in it. They can be as varied as real estate contracts. And so you need to have a clear understanding if there's a hunting lease in place, what happens after the conveyance. And then if it stays in place, then you're going to be interested in every single provision. But in addition to a hunting lease that we're familiar with, there can be grazing leases for cattle grazing. There can be scenarios where there can be all types of crop leases, as far as maybe that we're leasing out some of the hay production on a place, and we're doing on some type of split with whoever is actually coming and harvesting and baling the hay. And there can be all types of agreements, and that may or may not terminate with the sale. And so we're looking into those type of leases. When we have actual true crop leases, again, as far as what happens to the crop, now we have some pre-printed language, like in the temporary leases scenario. When there's a seller temporary lease, it addresses perhaps what happens to the crops even after the conveyance and during the before possession is given. And so we have to look at all the nuances, but there can be many types of these agricultural type leases that affect the property, and knowing what happens upon conveyance. And then if they are not going to terminate automatically on conveyance, we're interested in every detail because we are going to be the new landlord.
Right. So I'm sorry, we do have Jared actually posted, if you and we haven't gotten into mineral rights, but when we get there, Jared asked, if you purchase a new property and you don't own the mineral rights, how do you ensure a well is not drilled right in front of your new home built on your new property? Or how do you have some sort of say or leeway into where they put in their equipment or how they access the land that you just bought?
Right, and this is obviously there's a lot of detail to this discussion and so forth, but I'm going to break it down into some basics as best I can. Obviously that we have a scenario when you have the surface estate and the mineral estate severed from one another. Then you could have a scenario you would have conflicting interests. The surface estate owner is interested in how the surface is used, where the mineral estate owner is usually looking at only the investment from the production of the minerals from that standpoint. By default, a mineral estate owner has the dominant estate in the fact that the mineral estate owner by default, if there's no leases in place that modify this, has a right to reasonably use the surface in order to develop the minerals underneath it. When I say that, obviously comes to mind ingress and egress, but it goes beyond that. It's the actual use. You can use the groundwater. You can use sand and gravel. And so you can build roads. You can put up pipelines. You can put up drilling rigs and pump stations and so forth. Now, the reasonable, we can actually fill up my law office in every city we operate in with the short notes on the cases that have been argued over what the term reasonable means, just when it comes with arguments between surface owners and mineral estate owners from the standpoint. Because of the detail of the question, again, if you had 500 acres, it would probably be unreasonable for the oil and gas company to put a drilling rig in your front yard. In fact, there's actually some statutes about how close it can be to a residential structure. But even if it was met that criteria, but it was right in your front yard and impeded the use and enjoyment of your house, would probably be unreasonable if the oil and gas company could have just an effective of a drilling rig, 300 yards away that was out of sight and in a place where they could get to it from a separate road. That's, in ballpark terms, what's reasonable. In order to know what you have and don't have, a lot of time the due diligence that you will need to do as a purchaser of farm and ranch property, especially on larger acreages, is actually have the title examined for the mineral estate. This is the same work that's done by title companies as to the surface estate, but note that title companies do not provide title insurance for the mineral estate. So there's two things you're looking for in hiring a landman. It's an archaic term, but it's still commonly used. You're basically talking about a title examiner who is researching title to not only discover who owns the mineral estate, but in that situation, who owns the remainder, but also for all those leases, identify those leases. And know this as a side note that we call them leases, but they're actually a conditional conveyance of the mineral estate itself to the oil and gas companies for the exploration. And in that, we're trying to determine what rights are there, because these surface rights that belong to the mineral estate owner can be modified over waiving them over the years and also by the oil and gas leases. And so a landman can help determine what the usage of the surface estate can be used by this mineral estate owner.
Okay, awesome. I mean, we could keep going down this rabbit hole because just in you talking, I have about 5 or 6 other notes. But let's get back to other leases than just the mineral rights. Now, one of the things you covered in the class, and you touched on it as far as a lease goes for like hay production or crop production. One of the other things I want to be sure that all of our viewers know about is that, say you buy a piece of property and it's a corn producing farm or whatever, it's a crop farm, and you buy it and all the fields are full of whatever that crop is. Now, from what I understand, those do not convey to the new buyer, but those stay with the seller all the way through harvest. Is that correct?
That is in some of the pre-printed language. That could be negotiated any way the
Yeah.
buyer and seller want to. But in some of the
Right.
pre-printed language in the TREC forms, that
Right.
the crop harvest is that in that effect, correct?
Yep. And the impact of that is also things like timber. You know, if there's a timber lease or something along those, the trees may or may not, you know, particularly convey. All
Right.
right.
And the
So
revenue, we got to remember, is not only the crop itself, but if we have a lease in place, like an agreement with someone, a third party, the revenue that we're talking about off that and how that flows is extremely important.
yeah. Oh, thank you. I appreciate that catch. So we've talked about leases. Another one of the hot topics that always gets, you know what? I'm going to come back to easements. What I'm going to do is, since we've already started touching on mineral rights and water rights, let's go in there. You called them natural resource rights, and I think we've touched really good on mineral rights, but I want to hear your perception of water rights and how water rights are changing and how important it is for purchasers to know, purchasers and sellers to know and understand the implications of new legislation and new restrictions on how much water that they can either pump out of a river or a stream, or that they can pump out of the ground for whatever use.
Right. And I think we have to always kind of bifurcate or separate when we're talking about water. There's different kinds of water. And again, we have our riparian rights refer to our navigable streams, and we're talking about running water, you know, rivers, creeks, those type of things. And then we have groundwater. What surprises a lot of people is that groundwater is actually part of the surface estate. Seems a little counterintuitive because it's in the ground, but water is not a mineral. And so when we talk about mineral leases, it's not part of it. But how a oil and gas producer gets to using our groundwater is because of that default right to use the surface estate. But it is in fact part of the surface estate from that standpoint. And so again, what has been a tricky scenario in Texas, because we have a lack of water, and we're probably looking to have a lack of water more in the future than we do a surplus. And so it becomes even more valuable. And so just like anything else, if we can take the mineral estate and break it up into different rights, and we can take the surface estate and break it up into different rights, there's a possibility that we could sever the groundwater from the rest of the surface estate, in theory. Right. And so again, public concerns about that happening from a standpoint, overuse from the standpoint, or waste as it's called in legal term, come into concerns with that groundwater. And then when you're talking about a navigable a waterway that actually flows through multiple properties and throughout the state, from a standpoint, the use of that water and not creating waste, and special permitting that can be required to be able to use that water for commercial agricultural purposes come into play. And so that is those are all important scenarios. But again, it's important when you're acquiring property to understand if there are rivers and creeks, to understand what your rights to use that water for your purposes are. And also, if there is groundwater, you need to have a good understanding of, again, your ability to drill wells, what to get into different water layers, and how many feet that is, and what that costs. because not all property, you could have had an experience in one part of Texas to drill a nice water well for $5,500. And in some places, to drill a water well will cost you $100,000. In other places in Texas, it wouldn't matter if you had $20 million, you won't find water. And so from a standpoint, and so having an understanding of the groundwater available to you and what it actually costs to make it a resource for you is a very important part of the acquisition.
So what about hunting rights? So we covered that would be, I guess, another natural resource. What sort of restrictions or unrestrictions do you see as far as being able to hunt or shoot your guns on your property without it impacting your neighbor's property or your neighbor's?
Right. When we get beyond the lease, it's a contractual agreement about the hunting in a scenario. Then we have several different sources of law from that standpoint. Again, one of them, obviously, we have different hunting seasons, and we need to know that we have different zones in Texas. And so a lot of times we'll have a northern and southern zone that affects the different hunting seasons for a variety of animal, both fowl and four-legged animal. And so, again, we need to have an understanding of that. When we are in areas where we have a little bit more human pressure, meaning the places are not as large, we can get into the simple nuisance scenarios. If we're trying to have a skeet range and it's actually we're having scenario where we're blasting somebody's house almost from that standpoint, that can create a nuisance problem that's there that can come up that might not be there if we're on 2,000 acres in the middle of it from that standpoint. So some of our limitations there. There are also restrictive covenants that can affect the land. And so that can affect uses, and it can affect hunting. I see them more affecting domestic production of animals, such as, pig farming, dairy farming, those type of things more than hunting. But there can be, in a restrictive covenant, there can be any type of restriction. Mm-hmm. And those rules, those voluntary when we purchase the land, restrictions on how we use it, they follow the land, and so they move from one owner to the next from that standpoint, and that could affect hunting as well.
Yeah, I'm so glad that you brought up restrictive covenants. It's something that I've mentioned in my videos a few times. It's a double-edged sword, right? It's great in the fact that it protects you in some ways, but also it's something that you've got to investigate ahead of time so that you know and understand what the restrictive covenants. The example I use is, a guy moves out from Dallas or moves out from Houston and finds this lovely 20, 30 acres and thinks it's wonderful. And then all of a sudden, next door, the guy decides to put in a trucking, park, basically a what do you call them? Wreckage yard, right? And, sure. And just all of a sudden now the value of your house. So it would be great to have restrictive covenants on that. But then at the same time, if you're going out there looking for land and you want to, do something with your property, earning money like raising hogs, raising turkeys, putting in a chicken place, there might be restrictive covenants on it. So it's kind of a double-edged sword. Most of those originate from the county level, or where do those restrictive covenants normally come from?
They're generally, those are private documents. And again, the any type of government entity that has authority can invoke certain types of restrictions, for the area that they have governance over. But most of these restricted covenants are private documents created. And it generally works like this, kind of in your example, it would be, okay, I have 1,000 acres. And over time, I've decided to sell some of it. We're no longer in production agriculture. We just happen to live in the country now. And so we're going to sell some of this off. Well, I don't want to sell my land off to my new neighbors for them to put in that wrecking yard if I'm still living on the property as my primary residence. And so I set for both my piece of land and for the land I'm selling restrictive covenants to protect the land I'm selling from that standpoint. And so along the way, then those pass with the land, and they can actually create these restrictions that we volunteer to by acquiring the property.
That's a great example. Thank you. I really appreciate that. So one of the other things, let's circle back and go to a topic that we were going to get started on when we went to water rights and mineral rights, and that is easements and how we go about and discovering the easements. How do we remove easements? Can we get easements removed? Matter of fact, one of the questions and one of my things was, how can we legally, remove an easement after we've purchased it? And I gave, my 2 cents worth. I'd love to hear your answer to that question.
Right. And just like a lot of our other due diligence, again, having understanding of what type of easements affect the property we're going to acquire is super important. There can be all kinds of easements. There can be an ingress, egress easements. And so, okay, that means we have a scenario, either we're using an easement or, and probably the concern to us, we have someone else who is allowed to use part of our property to drive over to get to their property. Well, and I will tell you, just like any other document, not all documents are created equal. And there's an easement document. It's not just the drawing on a survey. There's actually a legal document that's created that part of the drawing on the survey. And there's a lot of times that important things are not contemplated, like who takes care of that road from that standpoint. Is it the person that holds the easement? Or is it the subservient, my land that is being used, or my land I'm going to acquire that's being used? Or somebody like falls down in that road and breaks their leg. Who's liable for that? It's my land, but you have an easement on it. Those are in many other scenarios are things that should be contemplated in a well-drafted lease. And even if you're not the party that's part of that drafting, you're buying the land much later, you want to have that easement evaluated. It's not just enough to know it's an ingress and egress, like what it's being used for. You want to know all the details about it and have that property evaluated. But there also can be like utility leases from a standpoint. And so a utility company could have a right to put transmission lines over a part of the property, or in a scenario or underground. From a standpoint, you can have pipeline easements from a scenario. All types of easements can affect the property. A very dreaded one is a lot of times that for money over the years, especially for utility companies and pipeline companies, that a former owner might have granted a blanket easement. That's where the easement is not for a particular 50-foot going down the west side of the property, but covers the entire property, allowing the utility company or the pipeline company to run lines and pipelines wherever they want to on the property. And so again, that's something good to know, because you're like, okay, the pipeline runs across the west part of the property, no problem. They call up, they're going to put another line. I really don't care. Stay inside your 50-foot or whatever, you're fine. Well, we don't have a 50-foot easement. We have a blanket easement. We're actually going to run it diagonally this time to link into another pipeline that wasn't there before. And so we're running our pipeline diagonally across your land, and we have the right to do so because we have a blanket easement. And so those are things that are in evaluation you need to know. The main scenario, I don't think you ever buy a property with the hopes that you can have an easement removed. You want to know that for a fact. And so the research and due diligence that you want to do is if there's a reason, a legal reason that you can have an easement removed, such as that it's been abandoned. And again, that doesn't mean nobody's used it this month. I mean, again, that's a term of art in legal terms that, again, we have to make sure all the elements are met for abandonment and those type of things. Or an easement, some easements can expire on their own within the framework of the document itself. It gives an expiration date or a condition of expiration from a standpoint. And so we need to evaluate those, but don't assume because the easement's in place, but you're the new buyer, new owner, that it doesn't relate to you, because these easements run with the land. And so you're going to be subject, you and your property are going to be subject to these easements. And so unless you've had a legal determination by a qualified attorney to know that you can remove that post-closing, don't assume that you can.
Yep. So you brought up, and I'm going to circle back on surveys. You brought up a very good point in the class that you were teaching a few weeks ago about the importance of getting your own survey done, and paying for and having that survey done. Do you want to go through some of the
Yeah,
points
I
that you
think
had
it's
there?
I mean, I just think it's a very important part of due diligence. Lenders and title companies a couple of decades ago uh, kind of eased up on some of their underwriting requirements where they did not necessarily require for the lending or for the title insurance to have a new survey with every transaction. It was standard for a few decades before that. And in that scenario, I think we've gotten too accustomed to using existing surveys. I see people closing, especially on farm and ranch property, with surveys that were done about the time I was born. So they're on parchment paper. And they have easements all over, and they're wondering if they still are there and still not. And again, so I believe, again, on all the different types of property I've acquired in my adult life, I believe in getting a new survey on the property. It's updated. You're in privity of contract with a surveyor. That means if the survey's wrong, you can actually sue somebody in addition to having a title claim that's there. There are endorsements that you can buy with title insurance that are very, very minimum in comparison to the overall owner's policy that give you coverage for the location of boundary lines, such as the property boundary lines, the boundary lines of any easements, or the boundary lines of any building setback lines. And so those are all important things to discuss with either legal counsel or your real estate license holder representative to understand the importance of those coverages and the importance of that having a survey. And a lot of times I simply recommend almost across the board, get a new survey, even if it costs money.
Yeah, the point that you made that I just really stuck with me is you don't have any, if you take somebody else's survey and use it for the transaction, you don't have any recourse back with that person who did the survey because they did it for somebody else. Their commitment was to somebody else, not to you. Whereas if somebody screws up your survey and you contracted them for it, you've got a recourse. They're responsible to you because of the work that they did. And I just think that's a really big point that is not obvious and not intuitive to most people. I have been asking for questions. We haven't had any more come up, and you've done a wonderful job of speaking to improvements and accessories because the contract doesn't really matter whether it's an improvement or an accessory because in the contract, the accessories that are conveying are in there or sort of similar. But one of the things that I think is always funny is stuff like mobile homes, deer feeders, corral pens, all of that looks to be real property is really not, right? It's has a tendency to be accessories. Do you have any past experience, any crazy stories about how that happens? Oh, one of the accessories that often is not covered and becomes confusing to people is the whole conversation around propane tanks and storage tanks. And it can be not just propane tanks, but I know that there's diesel stored on site or there's other storage tanks. Go through, do you want to explain to people sort of how that process
takes us
works?
a couple places. And one, again, we have to, again, we want to know not only if that is a fixture, depending on how it's built in, or an accessory, if it's not really anchored on any type of slab and so forth. And so is that, again, is that going to stay with the property or is it going to go with the seller? And then there's a second question we need to ask of actually who owns that, because a lot of times these are fixtures that are leased. And so we made it determined, hey, this is on the list, we're good. And so we get it. And then only to come to find out that the seller didn't even own it, much less us. And so from that standpoint, now we're subject to the fact that we have to go into a lease agreement, with someone and figure that out. And so we want, and if there's a fixture lease that's in place, it's going to have to be assigned to us and assumed by us and approved by a third party that we need to know existed. We need to determine that. And so when we're looking at the like these propane tanks especially, but also can, just like you said, can be other fuels. These tanks and the agreements to service them by bringing more fuel and propane can be in a place where a lease that's going to run with the land is in place, and it has to be dealt with, terminated or assumed.
Yep. Okay, that's great. Well, that sort of tapped out all the different questions and things that I had, all my notes. We've been running about 40 minutes. I guess I just want to turn it over to you, and what question should I have asked? Is there anything out there that you feel like someone who's never bought land and ranch before, who either lives in the state of Texas or lives outside of the state of Texas, needs to know that we haven't covered today?
I think that if we're not familiar with farm and ranch acquisitions, and in the scenario that I was looking to buy a farm and ranch, I think looking at that Trek farm and ranch contract gives you a lot of context of things, and probably will create a lot of questions. But you cannot beat having good advisors. So you want to be working with a real estate license holder who is absolutely familiar with farm and ranch acquisitions, just like doctors, just like attorneys. Again, not everybody knows everything within a whole industry. And so you need people that actually spend at least a large part of their time specializing in farm and ranch properties. I think that's imperative. Then you move that on to lending. You want a good lender that helps you not only loan you the money, but also looks to protect their interest and yours along with it. And so they run parallel with each other from a standpoint. And so having a good team of a good ranch broker and a good agricultural lender, I think you can't beat that. If you get into some of these sticky points, having an attorney that understands farm and ranch purchase and sales also can be helpful when you get into those sticking points that go beyond the purview of your lender and ranch broker from that standpoint. So those are having good advisors that you do your due diligence on as a buyer. Check out and see how, again, you look at how long have they been in the business, what kind of credentials they have, what type of track record do they have, what kind of frequency do they do these types of transactions, are all part of it, and I think are good due diligence on your advisors. And so having good advisors, I think, is probably one thing that I think is a good takeaway for anybody looking to acquire farm and ranch property.
It's great. Hey, I appreciate that. But you know what? One group that you didn't mention that I'm going to be sure and highlight is having the right title company that
Sure.
is going to provide you that insurance, stand behind it, and then also really help through that documenting and insurance. Well, JC, we do not have any outstanding questions. We've been going for about 45 minutes.
Okay.
I just would like to say thank you ever so much for taking the time to come and join us today, and look forward to continuing to work with you in the future. Okay.
Very good. Thank you so much.